state of Florida in this honorable court. Please be seated.
Well, good morning and welcome to a session of the 5th District Court of Appeals. I am Judge Monaco, as the Marshal has told you, and I have the pleasure of serving as Chief Judge of this court. With me today are Judge Sawaya on my right, your left, and Judge Cohen. We have 4 cases today. It's like 2 criminal, 2 civil. Criminal cases get 15 minutes aside, civil cases 20 minutes aside. If appellants want me to give them a heads up on a rebuttal, on saving some time for rebuttal, let me know and I'll be happy to try and do that. There is a clock on the podium, of course. One last thing, which is to turn off your cell phones, please, so that those arguing are not otherwise disturbed. And with that, we will begin with our first case, Holt versus State of Florida.
May it please the court?
Please begin.
Good morning. My name is William J. I represent the appellant Stephen Holt.
This is your first oral argument, isn't it, Mr. J?
It is, sir.
Oh, good.
I would like to reserve 5 minutes for rebuttal, and unless the court has any questions about the facts of the case or whether or not these were electronic communications which were intercepted under Florida statute, I'd like to proceed to discussing why neither of the 2 exceptions, 934.032C or D, apply to this case.
Go right ahead.
As far as C, which is the law enforcement exception, our argument rests on Wilson versus State primarily for the fact that law enforcement officers, as defined under this statute and interpreted under Wilson, mean law enforcement officers acting in their own jurisdiction under the color of law, unless they're investigating a crime which had already happened in their jurisdiction. So Officer Pineda and anybody from the Flagler Beach Police Department, unless they were investigating a crime that Mr. Holt had already committed in Flagler Beach, had no authorization under this statute to authorize contributors from the perverted justice team outside of their jurisdiction to intercept electronic communications. And in this case, the contributors...
Did you secure a ruling from the trial judge on that issue?
I tried to twice and I was unable to. The first order addressed only my secondary argument, which is that under the direction means something different than at the direction. I asked for a rehearing to address the primary issue, and again, it was apparently skipped over. So our argument is that because they were not investigating him for a crime he had already committed in Flagler Beach, Florida, they did not have the authority to authorize Eric Walker, the contributor in this case, who was in Fort Walton or Okaloosa County, to intercept these communications. Mr. Holt was in Orlando. He was not in Flagler Beach either. There is nothing to distinguish Wilson versus State from this case on that issue. As far as our secondary argument that we had made at the trial level, whether under the direction means the same thing as at the direction, I noted in my reply brief that there was a case by the 4th DCA recently, Meade, M-E-A-D, which had held that under the direction means the same thing as authorize. And they found that in that particular case, an officer authorizing a victim to record a telephone call or a future impending telephone call from the defendant was okay.
So Meade rejected your position on this?
They did, and I'm asking you to reject that position because under the rules of statutory interpretation, when a legislature chooses to use different terms as they did in this statute, they are said to have different meanings. And I outlined...
What did the 4th District say about that?
They didn't seem to address any issues about statutory interpretation on the use of different words by the legislature in different points of the statute. They simply said that authorized seems to be synonymous with under the direction.
Okay.
What I pointed out...
What's wrong with that?
Well, because authorized was used, I believe, 66 times, I noted in my reply brief, in the first 10 sections of this chapter, 934 in the Florida statutes. So if they wanted to use the term authorized, then they were certainly aware of that term because they used it 66 times in the statute in the first 10 sections. It's our position that by choosing under the direction as opposed to authorized or at the direction, which New Jersey did in the statute that New Jersey had, which is cited in one of the out-of-state cases, they actually chose to use the language at the direction. It's our position that there's a difference between under the direction and at the direction.
What is that difference?
Well, under the direction implies supervision, guidance, monitoring, input. The analogy I would use, and I believe I might have used in one of my briefs, is it's one thing for a field training officer who's riding along with his new police officer with him to say, get out of the car and go do that DUI investigation for this car we just stopped. And then just sit there and read the computer, read his BlackBerry, and not supervise, provide any input or guide that young officer through the process.
Well, in the order denying the motion to suppress, the trial court specifically quoted the statute and said that it expressly provides that it is unlawful for a person acting under the direction of an investigative or law enforcement officer. And then in the second page, having found that the communications were intercepted at the direction of. Isn't it clear from reading this order that the trial court meant at the direction of to mean the same thing as under the direction of in reading this order?
Yes, and that's my dispute, is I don't think that is what the law means. I think under the direction means different than at the direction.
Well, I know, but didn't the trial court's findings in this order, and it looks to me like it's a matter of semantics. He meant that under the direction of and at the direction of are the same thing.
Yes,
and
I believe
he
that's
made
what
a
he meant.
finding that it was under the direction of, essentially, didn't he?
Yes, sir.
Okay, so what is your dispute then? You're saying that doesn't comply with the statute?
My dispute is that is the wrong interpretation of the statute. That under the direction means something more. It means supervision, guidance, monitoring. I believe I listed...
Well, the trial court heard all the evidence and testimony, right?
Yes, sir, he did.
All right, and do you agree with me that essentially the trial court meant that when he said on page 2, at the direction of, that he essentially meant under the direction of?
I believe that's what he meant. I believe he was equating the two terms.
And he meant the two terms to mean the same thing, didn't he?
That's my understanding.
And so this particular finding you're saying is erroneous based on the evidence and testimony, even though it was a trial judge's responsibility to listen to the evidence and testimony and make the decisions based on that and rendering his factual findings?
No, we do not dispute any of the facts. We dispute the legal conclusion as to what the statute means.
All right.
To continue my argument about the analogy, it's one thing to have the young recruit officer go out and do something
just
at
to
the
make
direction.
sure I understand your argument, you're saying the trial court erred when he made the finding that it was under the direction of, in the order.
When he equates at the direction with under the direction, we are disputing that legal conclusion.
All right, it seems to me like it's just a matter of semantics, and then he maybe he used the wrong terminology in the second page, but he was trying to get to the fact that the statute says this, and he made the finding under the statute, and it's just a semantical error, it seems to me.
I think there's a huge difference between at the direction and under the direction. If an officer is supervising, monitoring, directing a young officer, he would go out there, watch the investigation being done, provide guidance if needed, and provide feedback. That is what the statute, in our opinion, means when he says, when the legislature said under the direction. Now, certainly, like in Meade, I don't believe that means that the officer has to be there right on top of the person while they're doing a controlled phone call or intercepting electronic communications such as in this case, but it does mean providing some sort of guidance, direction, and understanding of what to do. And the facts in this case are undisputed that it was Dennis Kerr from the Perverted Justice team who provided all the guidance, direction, and supervision to...
Well, what Perverted Justice does is they simply pose as a minor in a chat room and wait, right?
Right, but...
What more direction do you need from law enforcement? Wait while you're standing or wait while you're seated? I mean, what kind of direction is law enforcement to give?
Well, hopefully they would instruct them on how to avoid entrapping defendants. Hopefully they would instruct...
Entrapment wasn't raised as a defense in this case.
I'm not saying that it was. I'm saying you asked which direction should they give. And I'm saying that certainly in a discussion such as this, when a law enforcement officer is working with a private citizen, which is no different than putting a wire on a drug CI like they did in Wilson, you're certainly going to give that person some instructions as to how to conduct themselves when making controlled buys of drugs.
The law enforcement officer knew in this case that this was an organization that had been doing this type of work for an extensive period of time.
He did, but he still provided them no guidance, and obviously he didn't provide them any guidance under Chapter 934.
Is there anything in the record that suggests that he talked to them at all?
Yes, in the record,
What did he do when he talked to them?
he pretty much got their protocol given to him,
Okay.
and he said, oh, that sounds good, and he brought it to his
Do you
chief.
think that's direction? That sounds good?
I don't think that's direction. I think that's acquiescence to their policy and their guidance and their direction.
Wow, you are parsing a whole lot of words here. See, it seems to me that if he found out that they have a protocol, and that protocol is perfectly fine to him, simply saying, okay, do that, is a direction.
Well, except that then he let these folks go off in some, I mean, not in my particular client's case, but some of these folks were chatting for weeks at a time. In my particular case, it was December 2nd through December 8th. He never reviewed anything that was going on. He didn't review the chat logs to see if they were entrapping anybody or violating any other rules that might affect his cases that he was going to be bringing against these defendants. They didn't set up a...
How is that harmful to you? How is that harmful to your client?
Well, it violates the statute under our interpretation that they were not acting under his direction. They were acting under Dennis Kerr's direction.
I see your point. You're a little under 5 minutes left. If you want to save your time for a while.
Well, before you do that, your motion to suppress seeks suppression under 934, correct?
Yes, sir.
Okay. And 934.06 is the operable provision there. And it says whenever any wire or oral communication has been intercepted, no part of the contents of communication, no evidence derived therefrom may be received in evidence in trial, et cetera, et cetera. I'm sure you're familiar with that section. You'll note that that section does not include electronic communications.
Yes, Your Honor.
Do you think that Judge Sawaya was wrong in the O'Brien case?
No, I do not. That's why I cited the O'Brien case as my authority, as well as the Wilson case, that the discretion of the court should be used to exclude feloniously obtained evidence.
The statute, this isn't a Fourth Amendment issue. This is a statutory provision that you're seeking to exclude evidence on, and that specific, by its very terms, does not include electronic communications.
I realized that before I argued the motion. I believe I made it clear on the record and preserved my client's arguments under Wilson and under O'Brien for the grounds for the court to exclude the evidence.
Okay.
All right, counsel, you have about a little under 3.5 minutes left.
Good morning. May it please the Court. Assistant Attorney General Mary Jolly on behalf of the State of Florida. Focusing in on the narrow issue that the defense has talked about this morning, I think that Judge Hammond's findings that they were acting, and I want to use the term correctly, at the direction or under the direction of, was found properly. It's supported by the facts. He doesn't dispute the facts, and there's no abuse of discretion in that ruling. And I think that that's the bottom line here, stripping away the privacy
What about the
arguments.
jurisdictional argument?
I'm sorry?
What about the jurisdictional argument?
Judge Cohen, I've been thinking about that a lot. I think it's the state's position that given the context with which these electronic communications occurred, that this defendant can't assert the privacy-based right that stems from Chapter 934. That's our initial position, which the prosecutor argued below. Judge Hammond's finding that it was under the direction of...
Well, no, I'm not talking about that.
We're talking about the Wilson case, right?
Right.
Yeah.
Oh, the Wilson case? Well, Wilson's distinguishable on several grounds, and I thought about this last night when I was preparing. There was investigation, and Mr. Williams, the perverted justice operative, testified at the motion to suppress hearing that he was in Flagler Beach on December 7th, the day before the sting actually occurred. So there was conduct by
the
this...
initiation of the investigation, what contact was there with Flagler? At the time that the authorization is made and the go-ahead to perverted justice, Flagler County goes to perverted justice and says, okay, we're going to let you get to work here.
Okay.
Nobody from perverted justice was in Flagler County, correct?
Initially, no.
The defendant wasn't in Flagler County?
No.
Okay, so what was the jurisdictional basis that allowed Flagler County to authorize the interception of electronic communication?
I think it's investigatory at that juncture. It's investigatory. They're permitted to do their investigations, notwithstanding the
Flagler County Police Department wanted to investigate something that was occurring in Orange County. Do they have the authority to do that?
They can investigate a crime and work with that. They can investigate, but essentially, though, that what their initial involvement was what's going on in Flagler Beach. That's how Officer Panada even started. He was investigating what was going on in terms of this type of criminal conduct in Flagler Beach. He initiated his investigation and utilized perverted justice as a basis, as a tool for that investigation.
Did he contact perverted justice?
He did. He did, from Flagler Beach, because this is what I want to find out what's going on here.
So he pretends that, he's a minor, and after certainly inappropriate communications by the defendant in this case, he then brings that person into Flagler. He being? The decoy from perverted justice arranges at a house that the Flagler folks have set up to bring the defendant into Flagler County. And that's the only contact that the defendant has had with Flagler County up until that point, correct? Correct.
Those are the facts of the case. What's distinguishable about Wilson is nothing happened in the jurisdiction there. Nothing happened in the jurisdiction underlying Wilson.
At the time of the initiation of the electronic communications, nothing had occurred in Flagler County either.
But for the fact that Officer Pineda, he had done some initial decoying himself and had hits in Flagler County, which triggered his investigation in this case.
But nothing as it related to this defendant?
No, I can see that, nothing as it relates to this defendant, but in the totality, it's an investigatory process. And the fact that then the house was set up and the decoy is in, and he testified plainly, which is undisputed, that he was in Flagler Beach the day before, that chat alone is sufficient, the content of which is in the record, to eradicate and distinguish this case from Wilson, because there is conduct in Flagler Beach. He came to Flagler Beach, and there's the chat the day before. Nothing happened in the jurisdiction in Wilson, which makes that case distinguishable. And also, again, we're under a different type of crime and investigatory scenario and a uniqueness here that is just different from Wilson that we can distinguish this case from. It's the state's position. It's just simply not binding on its content. We're talking about a unique electronic communications case, and we do have conduct in Flagler Beach. So those bases alone, that Wilson, this court doesn't need to follow it because it's distinguishable and can't, I don't think it's foresight and can be, I think its application here, as I said in my brief, I think I used the word to be overreaching. Also, and I'd like to hear opposing counsel, with all due respect, alluded to subsection D, and as I was preparing for argument and looking at some of these cases from out of state, I think this court, and I argued in my brief, and I wish I had done it a little bit more expressly, under subsection D, by the content and basis for which these communications occurred, it's the state's position that there's consent on both sides by the basis of what these communications are and how they operate, and the lack of privacy that comes in by the plain fact that when you're instant messaging someone that you don't know in the world of the internet, you're consenting to whatever may happen to that. And I think Proeto, Townsend, and Lott, the three cases I cite from out of state, Pennsylvania, Washington, and Lott is New Hampshire, all of those do a nice discussion of when you engage in this type of conduct, you're consenting to its being recorded, transmitted, forwarded, cut and paste, and then on that basis it also pulls it out of and is not violative of the act, because if there's consent on both sides then there's no violation of Chapter 934. So I just wanted to highlight that.
The operative fact that it's a stranger, for instance, let's say that I go out of town and I want to communicate, we'll term them romantic thoughts to my wife. Does it make a difference if it's someone I know? Does it make a difference if it's a stranger?
No, actually it doesn't. And this is why, Judge Cohen, when you send your instant message out, and you're assuming the recipient sees and receive it. Is someone else there looking over their shoulder? You just don't know what's going on there at the other end. So there's just a lack of privacy inherent in that type of communication.
But if I'm on a phone call and I haven't consented to the recording of the phone call, I don't know if there's someone listening in at the receiver on a phone call, and yet that certainly would be protected under the statute.
Sure. That's a lack of consent on your part. I think the difference is when you engage in this type of communication over the internet in an instant message session, you're essentially implicitly consenting to that potential taping or recording or saving. And I think that's the difference by the nature. Well, you know, it's funny, when I was doing this, and there's warnings on these instant message, Hotmail, Yahoo, MySpace. There's warnings about this that while it's private, and they coin it private, they're saying, you know, while it's an amazing tool, you don't know where your contacts or what your people on the other end are going to do with what you send.
Is that in the record?
I'm sorry.
Is that in the record?
No, I'm sorry. That's internet. That's my understanding of the internet. I don't know what the person that's on the receiving end of my message.
I actually would like to know what's in the record
sense.
about that. As opposed
There
to
isn't any.
your
I
personal
apologize, Your
knowledge.
Honor. That's a day-to-day.
And completely inappropriate.
I apologize. I mean, I
You know better.
I know better. I did not mean it to try and cite something outside the scope of the record. Just as a common sense approach to this, I don't know where my message will wind up. And that's the reality of communications over the internet. I did not mean to disrespect the court anyway. It was just, as a practical matter, this is what happens, unlike a telephone call. So it's our position that there's an implicit consent, and I think that these cases out of state provide guidance in that, and that this court can also affirm the order on the basis under subsection D of the statute. In any event, Judge Hammond made findings. He found and correctly applied and properly applied the statute. Meade supports Judge Hammond's finding, and we'd ask the court to affirm. Judge Swyan? No? Okay. We'd ask the court to affirm unless there's no other questions. Thank you very much.
All right, you have a little under 3.5 minutes.
Addressing their arguments about subsection D, the consent by both parties, I agree that it is certainly well within this court's power to say that it is possible to implicitly consent. The Supreme Court just did that a couple weeks ago for waiving Miranda rights by silence.
Can you distinguish Meade from this case, and if so, how?
Well, in Meade, what we had is a crime that had already been committed by a known defendant or suspected defendant and a victim. And with a controlled phone call, or pretty much uncontrolled phone call in this case, they just said do it, record it. That is a much more simple process that does not require guidance, supervision, and direction, as opposed to this case where there was a week of chatting, 36 pages worth are in the record, that this officer and no officer ever reviewed to see if they were doing this properly or if the investigation was going in the direction that they wanted it to. No review whatsoever until after the arrest is made. Then they give over a dossier to the arresting officer and says...
And they kept a complete record, so it could be reviewed.
Except that it wasn't reviewed until after my client was arrested and interviewed and brought down to the Flagler County Jail. There was no supervision. Your client did show up in Flagler County, right? Yes, sir, he did. But I'd like to address, in the limited time I have, the consent issue. Certainly this court can say that implicit consent is possible, but there's nothing in the record of this case that shows that there was any implicit consent, either an express warning given or something that would have made any reasonable person, should have known that this was being recorded. What we have in the record is...
The point that was trying to be made was that when anyone uses the internet, you know that there are servers, you know that there are hard drives. This doesn't just go away into the...
Well, there's two kinds of storage. There's temporary storage, such as required for a human being to see information such as a text message, and then there's making that more permanent storage by doing what Eric Walker did in this case, which is choosing to log it into a permanent file instead of letting it vaporize when you click close in the chat window. There is a difference between permanent and the temporary storage, and I addressed that in my brief. And quite frankly, you will have to gut the statute if you're going to find that any electronic communication over the internet is implicitly consented to. That guts the entire statute. What this court should do is say, we are not going to gut this statute and interpret this clause out to be superfluous. We are going to find that implicit consent is possible, but there has to be some factors that show this implicit consent, like in the Townsend Supreme Court case.
Remember, though, that the legislature exempted electronic communications from the exclusion.
They did in the statute. I'm not arguing that it was a mistake, but clearly it was an oversight, just like
Why is it clearly an oversight?
Well,
Like the clause-
the federal courts take that route too, don't they?
I'm not sure how they interpret the federal statute on that point, but what has happened before, as in the Bryan case and in the Wilson case, they've said, we're not going to allow feloniously obtained evidence into even a divorce trial, never mind a criminal trial.
Counselor, your time has
Thank
expired.
you.
Did well for your first time.
Thank you.